The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your mostly bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by IJ attorneys Justin Pearson and Robert Everett Johnson. If you're new to the show, the basic idea is that we riff on 3 or 4 recent appeals court opinions that are important, but that you might not have seen in the news. And so now with that said, we're going to jump right into a case that you probably have seen in the news, the monkey selfie case. Justin, let's start things off with a solemn vow to our listeners that we'll make as few monkey puns as possible.
Oh, that's just bananas.
And with that out of the way.
Anyway,
Drop that Band-Aid.
So this is a case where the opinion was released 2 days ago by the Ninth Circuit panel. And basically what happened was a wildlife photographer took plenty of pictures of wildlife. But while he was doing so, he took a break, left his camera unattended. A monkey found it and took some selfies. When the photographer published the photos, he included the monkey selfies in them, which led PETA to file a lawsuit on behalf of this monkey, which it has no relationship, claiming to be next friend nonetheless, and asserting a claim of copyright infringement because, according to PETA, the monkey is the owner of the selfies.
What does next friend mean?
So next friend relationship is something that's statutorily created in certain situations. So, for example, with incompetent minors or in habeas petitions, you'll see it. And in fact, this is one of the things that was talked about in the case is at no point do the statutes create a next friend relationship regarding non-humans.
And yet...
Yeah, I mean, that's sort of the interesting issue here. So the suit was actually initially brought by both PETA and a doctor who's a doctor who works at this wildlife reserve where the monkey lives. And the doctor says, I've known the monkey its whole life. I'm its next friend. And, you know, it's at least somewhat plausible. But then for reasons that are mysterious and never elucidated by the opinion, the doctor drops out of the case. And so it's just left with PETA. And, you know, part of what the court is saying is, well, we have no real reason to think that PETA is actually friends with this monkey. I mean, PETA is a large organization that you may like or not like, but it's not really going around being friends with monkeys in any legal or non-legal sense.
So the court actually rules that the monkey does have standing, Article 3 standing, but not statutory standing. Talk about what that means.
Sure. So basically, after the court rules that PETA can't serve as next friend to the monkey, the court still needs to address whether the monkey can bring the case in its own right. And this is because of prior Ninth Circuit precedent in a case involving cetaceans, which basically means dolphins, whales, and porpoises. And so the court, following that precedent, begrudgingly points out that the monkey could or does actually have Article 3 standing, but does not necessarily have statutory standing. And so what happens is the court looks at the copyright statute and sees that it does not expressly provide for suits by non-humans. And so not only is PETA not a friend to the monkey, but the monkey does not have statutory standing in its own right.
Is it weird that a monkey has Article 3 standing?
Well, this is sort of, the panel seems to think so. And one of the things that's kind of going on here is that there's a former Ninth Circuit case that was brought by a lawyer on behalf of the entire worldwide community of whales. And this lawyer said, I represent the whales, and I'm going to challenge this underwater sonar program. And the Ninth Circuit said, well, you might have Article 3 standing. We're not going to say that, an animal can never have Article 3 standing, but Congress hasn't created a statutory right to sue, kind of what they did here. The panel seems, reading between the lines, to think that that is bonkers. The panel seems to think an animal should never be able to sue, that, when the Constitution creates the right to sue in federal court, that was a right for human beings. It makes a certain amount of sense. On the other hand, there's actually something kind of odd about some of the opinions in this case, where there's a concurrence from one of the judges who basically says, it's crazy to think that anybody could sue on behalf of an animal because how could we know what the animal wants? How could we know what's in the animal's interest? It's completely unknowable that, maybe the animal doesn't want to sue. Maybe the animal, is not really interested in what the person is doing. On the other hand, there are things that people do to animals where it's probably pretty obvious what the animal's opinion would be if, they could speak up, right? Like, take the whale case where the government had this underwater sonar program that was literally killing whales. Well, probably the whales weren't too happy about it. Like, they couldn't say so, but is it really like unknowable what the interests of the whales are?
Maybe
Like,
they were
probably not.
patriotic whales.
I'm still not quite over the standing thing. Talk a little. Well, first, let's say explicitly what Article 3 standing is.
Right. So for any non-lawyers out there, Article 3 is the article in the U.S. Constitution that deals with the judiciary. And so when we say Article 3 standing, what we're talking about is your ability to bring a case in court. And that's because judges can only resolve actual disputes, actual cases in controversy. You can't just bring a case because you're interested in an issue. And which is really actually what happened here, right? PETA was interested in this issue, and so it brought the case even though it had no relationship with the monkey. And so the court said that, as Rob pointed out, there are situations, at least under the precedent, where animals can have Article 3 standing, can conceivably bring a case in court. But even then, at least for the purposes of copyright, it would have to be something that's expressly authorized by the statute, and the copyright statute does not do that.
Really, when you're talking about constitutional standing, the question is, if Congress wanted to, could they allow a suit on behalf of an animal? Not like, should we let animals into court or not, but just like, say that Congress wanted to create a statute where people were allowed to bring a case on behalf of an animal. Congress has never done that. Could they do that? And the court's basically saying, well, maybe Congress could. At least we don't want to rule it out. And is that crazy? I'm not sure. I mean, there's something there, right? Like, the interests of animals are not as unknowable as some of the opinions suggest. Congress creates the right to sue on behalf of all kind of entities that are not human beings, right? Like, you can sue on behalf of a corporation, you can sue on behalf of all kinds of like various other sort of, not non-existent, but just not humans, in the sense that we normally think of humans. And why not say that, well, animals have legal rights and we're going to define who can sue on their behalf? It's not crazy that Congress would do that.
So I don't quite follow. Like, there is the Endangered Species Act, which prevents, like, for instance, a private zoo, like in North Carolina, I think, was recently sued because they had grizzly bears and they weren't treating them well, and activists sued. So were the activists just not suing on behalf of the bears in that case?
Yeah, the way it works nowadays is that you actually have to sue on your own behalf. And so you end up in these weird situations where people say, I'm suing under the Endangered Species Act, but not for the bears. I'm suing because I have an interest in going to see the bears. And if the bears are extinct, I won't be able to see them anymore, which is not really what's going on, right? Like, these people really want to sue on behalf of the bears, but because of the way the sort of legal world works, you actually have to sue on behalf of your own interest in looking at the bears.
Yeah, exactly. And of course, in addition to that, there are also suits brought by the government itself.
So the monkey has to be harmed in this case in some way by the copyright infringement. What on earth did PETA say was, the harm?
Well, basically, they claim that the monkey was the rightful owner of the photographs, and so its ownership was harmed by the fact that the photographer was claiming to be the owner of the photographs.
Well, fair enough. The photographer didn't snap the photo in question, but it was kind of his equipment.
Sure.
That he hauled all the way to Indonesia.
And I think this is, I've been kind of digging at the idea that we don't know what animals want, but there is in this particular case, I think, validity to that, right? Like, does the monkey really care whether it owns this photo or not? Who knows?
Did the monkey even know that it was taking a photo?
Right. Yeah.
Well, at the end of the day, I think the lawsuit is definitively over now.
Right. The panel was not impressed with this lawsuit, and there is a very loud subtext that runs throughout this opinion that basically says, go away and don't come back.
And with that note, we'll move on to the next case, which comes out of the Fourth Circuit.
Yeah, so this is a case that is kind of about the Pharma Bro, although he's not actually a party to it. And the Pharma Bro, for those who don't know, is Martin Shkreli, the erstwhile CEO of a pharmaceuticals company, among other things, who's currently facing all kinds of other legal troubles. But the thing that I think launched him into prominence was that he purchased this old drug that had been on the market for a long time, an important drug, and he raised the price by like 1,000% because he realized that
5,000%.
Yeah, because nobody else was selling it. And so in response to that, the state of Maryland passes a law that they call their price gouging law. And basically what they say is that it's illegal to raise the price on a pharmaceutical drug in a way that is basically what they call an unconscionable increase in price. Now, what does that mean exactly? It's probably hard to apply in practice, but certainly the Pharma Bro circumstance would probably qualify. Now, the people who sue is an association of pharmaceutical makers who basically say, that may or may not be good policy, but it's not something that Maryland can do, right? The federal government could certainly do that, or probably could do that, but Maryland can't. And the reason is because the price of pharmaceuticals is not set just in the state of Maryland. It's set by pharmaceutical companies who are selling to middlemen, pharmacy companies, things like that. And they're making these transactions outside the state of Maryland. And while Maryland can regulate things that are going on inside Maryland, they can't regulate things that are going on elsewhere. And that's called the principle of extraterritoriality.
Right. And of course, that makes quite a bit of sense, right? I mean, as the opinion points out, if you allowed a state to regulate what's happening in a different state, well, then what happens if that other state regulates it differently? You could put the person in a position where they literally can't follow both sets of laws.
So the framers were trying to create just a massive free trade area, basically.
Yeah, and it's called the Dormant Commerce Clause, which is kind of a weird name. But the idea of it is basically the federal government has the power under the Constitution to regulate interstate commerce. And in order for the federal government to have an effective regulation of interstate commerce, then the states can't regulate interstate commerce because otherwise you get 50 sets of regulations and nobody knows what to comply with.
Why is it called dormant? I mean, it's the Commerce Clause. It's plainly being used for constitutional cases. Why is it dormant?
It's an archaic phrase that I think really what it means is implicit. It's implicit in the power to regulate interstate commerce that the states can't do it.
Right, and by that, obviously, Rob means that it's not stated, right? If you look at the Constitution, you can't say, oh, where is the Dormant Commerce Clause stated? You can see the Commerce Clause, you don't see the Dormant Commerce Clause, but it just logically follows that, the results of the Dormant Commerce Clause jurisprudence must be true once you think about how the Commerce Clause works.
Okay, let's get into the case. What does the Fourth Circuit say about this law?
So the Fourth Circuit agrees, and what they say is basically, the position of the state of Maryland is, look, at the end of the day, the drug is being sold in the state of Maryland, so we have authority to regulate everything about that transaction. What the pharmaceutical people are saying is, sure, the ultimate sale happens in Maryland, but you're actually trying to regulate what they call the upstream sale from the manufacturer to the intermediary, which, again, is not happening in the state of Maryland. And the Fourth Circuit agrees. They say, look, Maryland, you can regulate the sale of things that happen in Maryland, but you can't regulate sales that are happening outside the state, even if they relate to things that are ultimately going to be sold in Maryland. There's an interesting dissent, which basically says, look, that sort of definition of intrastate or in-state commerce, is kind of like the same thing that the courts were doing with respect to the federal government back in the 1930s, when they would say, well, the federal government has the power to regulate things that are going between states, but then not the power to regulate things that are entirely within states. And that's all been kind of thrown out the board with respect to the federal government. We just say everything relates to interstate commerce because it might conceivably have some relation to something that happens in the interstate market. Why don't we do the same thing with respect to states and say, everything relates to everything in the whole country relates to Maryland because it might have some conceivable impact on what happens in Maryland. So, under the same theory that allows the federal government to regulate everything, Maryland should be able to regulate everything.
Right, and the dissent actually, as you might guess, cites to Wickard v. Filburn, which should make us all very angry. But there is actually a fine line here, right? Because there are situations where a state can regulate something that within its own borders, where the indirect effect of that is that the producer or just the chain of suppliers will change how they do things in order to meet those requirements. And that doesn't necessarily violate the Dormant Commerce Clause. But here, at least in the opinion of the majority of the panel, Maryland went too far. Maryland crossed that line by regulating activities outside of their state in a more direct fashion than they're allowed to do.
I have to ask, if a state wants to stop these insane price increases, what are their options constitutionally?
Well, they can regulate what's actually happening within their state, or it's up to Congress.
Yeah, I think really ultimately this is an area, it's an interstate market. It's definitely not something that's happening within each state. And if you're going to have any kind of regulation of this, it's going to happen at the federal level, especially because it's an area that's already so highly regulated by the federal government already. The idea that the 50 states are all going to have their own solutions for this is just bonkers.
Bananas even. Okay. Justin, let's move on to the Sixth Circuit.
Sure. So this was a recent decision out of the Sixth Circuit involving metaphysical questions regarding whether the increased chance of reward in the afterlife constitutes compensation, and conversely, whether the risk of eternal damnation constitutes coercion. And so basically what happened here is that there was a restaurant that was wholly owned by a church.
The Cathedral Buffet.
The Cathedral Buffet, right. Sounds delicious. And so basically, even though the Cathedral Buffet was technically a separate entity, it was operated by the church. And like many of these types of entities, it had full-time paid workers as well as volunteers who helped out.
From the church.
From the church, exactly. And so what would happen is the reverend, while preaching, would cajole the parishioners to volunteer at the Cathedral Buffet. He would not be very subtle about it either. I mean, he'd basically give them the impression that if they wanted to make God happy, they needed to go volunteer, and if they didn't volunteer, God would be very unhappy. And there was actually testimony from the parishioners that they believed this, that according to their religious beliefs, they thought that it would make God happy for them to volunteer and make God unhappy if they didn't volunteer, and this motivated them to volunteer. And so what happens is the United States Department of Labor brings a lawsuit against the Cathedral Buffet, saying that these volunteers need to be paid. And the logic is that, while volunteers don't need to be paid, once they receive some sort of in-kind benefit, the compensation doesn't have to be money. It could be something else. Once they receive some sort of compensation.
The restaurant/church gets the kind of benefit?
Well, no, once the volunteer is receiving a benefit. So, for example, if there's precedent where volunteers receive, free food, free clothing, housing, and so that triggers the regulation. They're no longer volunteers, which means they have to receive minimum wage. And so the question becomes, well, does this increased chance of receiving rewards in the afterlife constitute the type of in-kind benefit that triggers the minimum wage requirements?
And conversely, also, if you're being compelled to be somewhere, coerced to be there, then you're no longer a volunteer. You're, basically, I don't want to say a slave, but you're basically a slave, right? You're working for free and you have no choice about it. At that point, too, you have to be paid the minimum wage. And so the other question is the fact that you're, faced with eternal hellfire if you don't show up at the Cathedral Buffet, does that mean that you're essentially a slave?
Yeah, I mean, that's a fair point. I also want to point out something that wasn't addressed but struck me, that, even if you were to follow the logic of the government with all of its other issues that are pointed out in the opinion, it would occur to me that if, going to heaven was a form of compensation, that would surely exceed the minimum wage. There are two main questions, and then they're buttressed by another question. And so the two main questions are, as we mentioned, whether the possibility of rewards in the afterlife meant that these volunteers need to be paid a minimum wage. The second question was whether the threat of going to hell was enough to constitute coercion. And then, of course, buttressing these is an interesting argument that we've addressed in some of our other cases, which is whether the fact that the restaurant used volunteer unpaid workers meant that it was unfairly competing with businesses who pay all of their workers, which is an issue that is near and dear to my heart, because it was actually one of the arguments we faced in a recent case in New Jersey involving the right of the Archdiocese of Newark to have to basically sell tombstones through what they call the inscription rights program. And I should just to start with the last first. The court correctly points out that cannot be the rule, right? I mean, there are countless examples throughout all of our society where nonprofits or businesses that are hiring volunteers compete with other types of businesses, and you cannot call that unfair competition. Soup kitchens compete with restaurants, volunteer programs where you build homes for people who need homes. They compete with construction workers, and so on. I mean, you can come up with many examples. And so the court correctly points out that this is not unfair competition. And I would say the court also does the right thing in pointing out that whatever you think of the afterlife compensation the volunteers may receive, these acts do not compensate, did not qualify as compensation or coercion for the purposes of the statute. And so, the conclusion is that the restaurant wins, although it's a bit of a Pyrrhic victory. And this is pointed out in the concurrence that, before this lawsuit was filed, the restaurant had 35 paid full-time workers, but because of this lawsuit, the restaurant closed and those workers all lost their jobs. And so that's really unfortunate.
Yeah, this is one of those weird cases where, and it's important to remember here that the lawsuit is not brought on behalf of these volunteers. Like, there's no indication that any of the volunteers are, upset about this or want to go to court to, they're not trying to sue their reverend. Instead, this is a lawsuit that's been brought by the Department of Labor and the Federal Department of Labor, right? And you got to think, don't they have something better to do than going around the country, suing a church because it's having its parishioners volunteer in a restaurant? It's just kind of bizarre. And then at the end of the day, the court reaches the right result. But as Justin mentioned, the restaurant closed, they fired all the employees. And also, the legal bills in this case have just got to be extraordinary to fight this all the way up on appeal. And,
They weren't hurting anyone.
Yeah, they weren't hurting anyone. What is the Department of Labor doing bringing this kind of case? It's bananas.
And this is the point made by the concurrence, which I thought was very well written, talking about this power grab that is going on, or that was at least going on at the Department of Labor when this suit was brought. And it ends with a quote, with a paragraph that I would like to quote, because I think it really sums up the issue and the fear of what might happen if this type of approach were allowed to stand. And so what the court says is, quote, "What is perhaps most troubling about the department's position in this case, however, is the conceit of unlimited agency power that lies behind it. The power of a federal agency is no more than worldly. The department should tend to what is Caesar's and leave the rest alone," end quote. And I think that perfectly sums up just this concern that the court rightfully had, that the Department of Labor was really going far outside of its purview in trying to claim that because of religious issues and kind of promises of what may come in the afterlife, it thought that it could now regulate volunteer work done by religious people. It just makes no sense, and it's a shame that the Department of Labor even chose to take that approach.
Okay, let's move on to the final case, which comes out of the Seventh Circuit. Rob?
Yeah, so this is one of those cases that, if it wasn't tragic and horrible, might almost be kind of humorous. What happened, it's a case that arises out of Peoria, Illinois, and there's a shooting. And the victim of the shooting, I don't think he's actually, he survives, and he's, at the time, was high, and he's brought in, and he basically says, "I don't remember who, the perpetrator was, I couldn't describe them." But 6 months later, he's brought in again, and he's shown a lineup, and he identifies this individual, Mr. Jackson, from the lineup. Now, at this point, the police go out, they arrest Mr. Jackson, they bring him in, and at the time that they bring him in, he's also high, and he's also drunk, and the cops interrogate him for about 2 hours, and while he's still intoxicated.
Literally falling off of his chair intoxicated.
Right,
Literally.
He passes out, and they have to take him to the hospital.
Yeah, so at the end of the interrogation, to fast forward a little bit, he actually passes out. And in the interim, they tell him, look, you're a young black guy, and trials are biased against people like you. You're going to be convicted even if you didn't do anything wrong. Here's a story. You did it in self-defense. It was, you didn't really do anything wrong, but you felt like you had to do it anyway. And so he's kind of, starts making inculpatory statements where he says, okay, yeah, that's what happened. Even if it's not exactly what happened or not at all what happened, you can see how somebody might do that, especially when they're drunk, right? Okay, so the case goes to trial, and he's actually convicted. And so this is just like a tragedy, and it's just awful, right? You have somebody who he's being convicted based on an identification by somebody who was high, based on a conviction that he made while he was high and drunk, right? So it's just awful. And rightfully so, the conviction is reversed on appeal, and he brings a suit for a civil rights violation, claiming that he was coerced into an involuntary confession. The officers then move to get rid of the case under what has got to be our favorite doctrine, the doctrine of qualified immunity, something that comes up on the podcast all the time. And for once, actually, qualified immunity is denied. The district court says,
Although just at this beginning stage,
Right.
we
No,
don't know whether he's going to win.
Yeah, no, that's true. That's true. He could still lose at the end of the day. But at least on the pleadings, at the very beginning of the case, the court says, look, there's enough here to deny qualified immunity. And the officers try to appeal. And on appeal, the Seventh Circuit says, no. There's at least under the pleadings, there's no legal issues here that would warrant denying qualified immunities or granting qualified immunity. And there's really two arguments on appeal. The first is, look, the court should have looked at the video. And according to the officers, if you look at the video, he's not actually that drunk, or, which is a little weird because he passes out after 2 hours. But, they claim that he doesn't actually seem that drunk. The court says, look, this is just on the pleadings. It's just, this case has just been filed. At the pleadings, we take the allegations as true. We're not going to go to the videotape. And the second claim is, well, the mere fact that they made these comments about, juries being biased against black people is not enough to make the confession involuntary. And the Seventh Circuit says, well, okay, fine, but that's not his claim. His claim isn't just that they made those statements. It's that everything else that happened too, right, made this confession involuntary. So, I think at the end it's a pretty easy appeal for the Seventh Circuit. They knock it down, and the case goes forward. So it's a rare win for somebody faced with a qualified immunity defense.
Right, and obviously, the way qualified immunity works is what happened has to be well established as being unconstitutional or a violation of your rights. And here, what is sufficient to maybe give us hope that this guy might win is that the court comes right out and says that at the time of the interrogation, it was well established that someone under the influence of alcohol or drugs might be especially susceptible to coercion. And so it sounds like this guy has a chance. Now, we have to see, what he can prove. We have to see where the facts, take the court. But I'm saying there's a chance, so we'll see.
And, with qualified immunity, I mean, the problem with the doctrine is it always just depends on the level of generality that you stated at, right? Sure, it's well established that a person who's drunk and high can't, may be susceptible to, a false confession. On the other hand, what if he's also told that black people don't get a fair shake? Well, I don't know. No one's ever addressed that before, so, you're entitled to qualified immunity. I mean, that could happen. It might not happen, but it's a doctrine that turns out to be endlessly malleable.
Yeah, and that is the sad truth, that even when it looks like something is, on all fours with existing precedent, the courts have been extremely creative in distinguishing cases and not allowing suits against law enforcement officers for really, meaningless differences, just details that don't matter. And so hopefully that won't happen here, but we'll have to wait and see.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, beguiling you to get engaged.